precedent. So I see there's no precedent for me being funny. So I say a really dry joke and no one laughs and they think I'm being serious or think I'm being a jerk. But I, in my head, am just like, it's a Jason Bateman zinger.
Sure.
But my husband could say the same thing and people belly laugh. But it's because there's precedent. There's precedent for him being funny. So yeah, you just have to create precedent, and you start that by stop saying,
I will remember
I'm not funny.
I will remember what you're saying.
And your girlfriend needs to start telling you you're funny.
Hi, besties. You know what they say is that what you put into this world is what you get out of this world. There's a lot of different theories that they talk about this in. There's a biblical concept that if you put out good fruit, like the fruit of what you've done is the fruit that you will receive. And if you put out good fruit into the world, good fruit will be given to you. If you put out bad fruit, you can only expect bad fruit to arrive. There is a karmatic theory about this. There's a universal one where if you put out good energy, you'll receive good energy. If you treat someone badly, they will treat you badly. There's the golden rule: treat others as you would want others to treat you. And if you don't treat others well, that means others aren't going to treat you well. Well, there's this whole give and take that happens when you are someone that doesn't treat people well. And it would appear that Ryan Reynolds and Blake Lively's attempt to literally go after the internet is blowing up in their faces, with more and more content creators filing motions to quash. And it's even gotten the attention of a British actor, Omid Jalili, who is known for appearing in several films, including Gladiator, The Mummy, Alien Autopsy, Spy Game, Sky Captain and the World of Tomorrow, Grow Your Own, Notting Hill, Mr. Knights, Pirates of the Caribbean at the World's End, Sex and the City 2, and does the voice in Over the Hedge. He also is the voice of someone in Grand Theft Auto, the game. So he is a comedian, actor, and well known in Britain. And he was so annoyed by what he's been seeing with what's going on with them. He said this: "It's time to speak out. I don't usually in such cases, apart from the odd joke here and there, but the Baldoni and Lively case has taken a very dark turn, and it's definitely not Amber versus Johnny and never was. It now involves us all, and it is way more serious than the gossip columnists would have you believe." Recap of timeline. After the release of the film, It Ends With Us, last August, Blake Lively promoted this movie about domestic violence by amazingly pushing her various alcohol brands. This tone-deaf marketing by Ryan Reynolds' marketing company, Maximum Effort, received a massive backlash as the significant connection between alcohol consumption and domestic violence is a known fact. Yet instead of apologizing and moving on, Blake claims the online criticism of her was all an untraceable smear campaign. To effectively uncancel herself and deflect from the catastrophic marketing campaign of the movie by husband Ryan, she then launched a smear campaign of her own, accusing her co-star and director of the movie, Justin Baldoni, of sexual harassment, with a much publicized article in the New York Times, December 21st. After Baldoni's lawyer, Brian Friedman, dropped receipts that no sexual harassment had taken place, and the man Blake accused of orchestrating the smear campaign against her crisis manager, Jed Wallace, being dismissed from the case, she is now going for anyone who has criticized her online. 16 content creators on YouTube and 20 on X, literally tracing the supposedly untraceable content to those people, some of whom have as little as 38 followers. This has massive implications on free speech, attempting to stifle and chill voices who are simply interested in the case and commenting on it. These people are now being dragged into federal court. Fortunately, they are all firing back, and the previously silent mainstream media are now saying, when you demand IP addresses and PayPal receipts from hobby vloggers, you risk being seen as mugging the First Amendment in broad daylight. Daily Mail Online. The big issue here is privacy trust, with social media platforms giving up personal information to people like Blake Lively and Ryan Reynolds so they can bully and threaten them away from the cameras. This is disgusting. And why are they doing this? Blake Lively seems to be her own worst enemy. This is a strategy that can only blow up in her own face. Ryan, too. Believe it or not, I like these two, or did. But this behavior has shown us who they are. No one should be fearful of speaking out against the actions of rich and privileged actors who continue to behave disgracefully with impunity. They cannot use mainstream media to control their false version of events and then punish social media users when the public goes against their narrative seeded through the high profile media outlets. Shame on Blake and Ryan's law firm for issuing these cowardly subpoenas. If you want to subpoena me for saying so, go ahead, make my day. Especially when we all know, even you, that the real culprits are staring at themselves in the mirror. And then he shared a photo of them looking in the mirror. So Omid has a pretty extensive acting career, and he's also known to be a comedian. And he's someone that has, done shows, comic shows, gone on comedy tour. He's teamed up on television programs in Britain to find Britain's best comic. This is someone that has a significant platform that's, basically stating that they've crossed a line and they're seeing it for what it is. And I really want to just thank him because in his statement, specifically, he outs the media, right? And that the mainstream media is being seeded with high profile, their narrative is being seeded through high profile media outlets. So he's saying that they are controlling the mainstream media with a false version of events and then attacking anyone that sees the truth or literally just asks questions. So he's got a lot of traction. In fact, that has been liked 3,000 times and been seen 236,000 times on Twitter and has been picked up multiple times online. So thank you, Omid, for speaking out. I wish that more celebrities that were watching this that know what's going on would say something. I think part of the reason why so many are not is because they don't want to get pulled into it too, and they don't want to be subpoenaed, and they don't want to get a part of the legal problems, and people are afraid of Blake and Ryan. But, at some point, the mainstream media needs to stop placating these people. Truthfully, like every single outlet that continues to push their rubbish simply because they think they're going to gain access to Ryan or Ryan threatens them. What do you stand for in journalism if you don't stand for the truth? The outlets that continue to pander to them are proving that they lack credibility and simply only care about access to power and wealth. Now, with that statement coming out and someone actually making some ruffling feathers, there's been a couple motions to quash filed. I did speak to Mackenzie and Ashley about their motions to quash. Both of them said that they got help from Cassidy. Cassidy and Leanne apparently did this online in a video. They went live and talked about their motions to quash. They worked on them together. Leanne helped. She has a background in law in Britain. And Cassidy provided then a template that was used by other people. So Ashley told me she got her template from Cassidy, and Kenzie did too. Kenzie's is a little bit different than the others, so I want to talk about hers. Ken's is a creator that at one point in time only had one follower on her YouTube channel when it was actually subpoenaed by Blake Lively. And when I first reported this, I think all of her videos only had like 2,500 views. So hers dives into more the aspect of freedom of speech. And I like this take on it as well, because I think the judge needs to hear this. The motion seeks to protect Moven's constitutional right to freedom of speech. The subpoena demands personal identifiable information, including my name, address, IP history, and financial data, without establishing the content posted by Existing to Thrive and how it's actionable or relevant to the underlying litigation. This is something that we've been talking about behind the scenes and in our group chat, is that she wants all of this information from us, but her attorneys will not identify a single statement or video we've posted that they find objectionable that they believe is somehow tied to this. She said granting such a subpoena without a compelling evidentiary basis will go against the movement's right to protected online speech and violate the First Amendment. So she says she's number 16, existing to thrive, an independent online commentator who posted videos online discussing the widely published case Lively versus Wayfair. It is crucial to note that everything discussed in their videos are cited from published articles that are readily available to the public. It's also important to note that the case Lively versus Wayfair is not the only topic that movement covers on social media platforms. On July 10th, 2025, she became aware of the subpoena. She requested a copy of it from Google and Ezra Hudson via email. That morning, she called Ezra's office and left a voicemail requesting confirmation of the legitimacy of the subpoena and a copy of it. It was not until July 14th that the movement received a copy of the subpoena from Google at 12:56 p.m. at Ammanat Phelps and Phillips at 3:53 p.m. And then she goes into what it's looking for, which by now we all know. And she discusses the legal standard of they must quash or modify a subpoena. She is going to use the First Amendment because it protects the right to anonymous speech, especially on matters of public concern. And she said she has not engaged in any defamatory or illegal conduct. The subpoena appears to be aimed at identifying critics or speakers in a high-profile entertainment dispute. Compelled identification is, in this context, constitutes retaliation against protected speech, absent a threshold showing of actionable wrongdoing. I really like how Mackenzie used retaliation against protected speech, because Blake has been saying for months that they are retaliating against her, but really she's retaliating against Wayfair and all of us who become her victims. She goes into a case that made malice and has identified what malice means for public figures when it comes to defamation. This is the groundbreaking case, New York Times versus Sullivan. And she says commentary on public issues should be uninhibited, robust, and wide open. It was said that vehement criticism and even mistakes were part of the price for freedom in a democratic society. And in order to protect open discourse, the court made it clear that a public official suing for damages had to prove the existence of actual malice by convincing clarity. Thus, Ms. Lively would need to prove with strong evidence of any connection to her claims of a smear campaign before gaining access to private information of the movement. So, one of the biggest issues for all of us, I will say, is that absent this concept of a smear campaign, nothing that she has stated in the court actually is defamatory. It is not defamatory to call someone a bully or a mean girl. It's also not defamatory for people to react and post videos of things that she says. Actually reacting to what she does isn't defamation. She's not been accused of crimes, I mean, until now, right? And she hasn't identified what any of us have said or done that would qualify as defamation, because a smear campaign is not actionable. It's not even a legal standard. Content creators have a right to discuss and question her claims in an ongoing public case. The subpoena issued by Ms. Lively to those covering a public lawsuit appears to be an attempt to intimidate and silence criticism. She then shares that she had one subscriber on YouTube when she got this subpoena. This proves the complete proportion of Ms. Lively's fishing expedition. It suggests that plaintiff is not pursuing legitimate evidence, but rather attempting to identify and intimidate critics. The subpoena issued by plaintiff reflects a speculative fishing expedition rather than targeted searches for evidence. The lack of any factual basis for such invasive requests strongly suggests that the so-called smear campaign alleged by plaintiff has no foundation in reality. The plaintiff has not proven actual malice to demonstrate necessity for this subpoena. When it comes to her First Amendment rights, Kenz's, Ms. Lively needs clear evidence justifying her infringement on movements' rights to post commentary on legal cases initially made public by her team, Ms. Lively. Negative commentary or opinions regarding Ms. Lively or this case does not constitute sufficient evidence that movement had any involvement in a smear campaign. Considering the movement was not monetized on YouTube prior to receiving the subpoena, further demonstrates how unnecessary the subpoena is. She has provided Blake no evidence that her speech is defamatory, unlawful, or even relevant to the core claims in her underlying litigation. It fails to articulate why unmasking an anonymous content creator who has merely commented on publicly available information is necessary to advance her claims. I'm glad to see at least one person really drive home that fact, because it's something, again, that we've been talking about a lot behind the scenes, is how much she won't tell us about what we've done that she claims is what her evidence is or her proof. She's then accused of causing irreparable and substantial harm to Ken's. Miss Lively is a high profile actress with over 40 million followers on her social media. The power dynamic between movement and plaintiff is substantial. Considering how publicized Miss Lively's case has been, it is in the best interest of the movement to not disclose highly sensitive information to protect against movement being doxxed. Miss Lively has already put the movement's safety at risk by making claims that content creators who have been the subject of discovery have already painted Miss Lively as the aggressor in this lawsuit and have drawn a false equivalency between her discovery efforts and the Wayfair party's alleged smear campaign. Miss Lively is using the legal system to elude that the movement is harming the plaintiff, again, without any evidence. These comments made by Miss Lively's counsel motivate retaliation from Miss Lively's fan base. It is hyperbolic to assume that a small creator like the movement would have an effect on her safety, Miss Lively's safety. However, it is not only realistic, but expected to be the complete opposite for the movement. The First Amendment protects the right to speak anonymously, particularly on matters of public concern. Without a showing of actual malice or compelling need, disclosure would create a chilling effect not only on movement, but on all creators and commentators participating in public discourse. The plaintiff has not offered any showing that anything she said is actionable. Nothing she said has constituted defamation, would warrant a sweeping request for sensitive information. And absent clear evidence of wrongdoing, compelling disclosure in this context would undermine the First Amendment protections and set a dangerous precedent for targeting online speakers. She's seeking to quash the subpoena for her account, a protective order from barring Blake from further abusing discovery without prior court approval, sanctions under 45D1 for issuing an overbroad and harassing subpoena that appears designed to chill First Amendment protected speech rather than obtain discoverable information. She requests reasonable court costs associating with responding to the litigating this motion and grant other such relief. And then she shared her communications with Lively and others, or with Google and the subpoena. And then Ashley, who is the user, Ashley Brianna Eve, she filed a motion to quash using sort of that same template of that Cassidy and Leanne had put together to help people if they wanted to file their own motions to quash. And she's a Canadian citizen. So her argument to the court is that this court has no jurisdiction over her and she's not entitled to obtain documents from a non-party in Canada, and they have to obtain leave from the Canadian court and show that a non-party's evidence is sufficiently relevant to material issue in the action. She has to go to court in Canada to do this if she wants the information from Ashley, and she didn't do that at all. And something that she wrote here is interesting. Miss Lively throws tantrums about her own privacy and safety on a regular basis, but does not afford those rights to anyone else. Despite the instances mentioned in this paragraph, the public has not seen a single instance where the court has given the plaintiff's counsel the slightest discipline or warning as a result of their professional incompetence in this regard. To Lively consistently filing service documents, so requests to serve people in the case. And when she files the notifications from the process servers, she puts their full address in this, files into court, doesn't redact their addresses, which is part of their protective order, and does it anyway, putting people in danger. She also took a jab directly at the way that they decided to do the Van Zandt lawsuit. and said, while attorneys affiliated with Manat, Phelps, and Phillips may be accustomed to filing sham doe lawsuits, as they have done in this case, to access the entire contents of defendant Jenny Abel's phone, possibly committing federal and state crimes, where they slip in and file a bogus complaint with a pretend cause of action using a client's shell company, served an underhand subpoena to whitewash information they may have already had, avoid assignment of a judge to avoid the necessary prima facie showing, and then quietly withdrawing it with no member of the court ever knowing its existence. The rest of civilization understands this is not the way that we do things. Every person being served a subpoena has a right to be notified, legally represented, and protected either by counsel or in a standard lawsuit or by a judge. And this one also focuses on the irreparable harm that she will cause to her because of she's owns an animal sanctuary and she runs a farm, and she's concerned that if she were to release any information related to her, um, her life and her privacy would be in danger. And that if the court indulges this, it would set a dangerous precedent, destroying the first basic right of the citizens of this country, their right to free speech. And Ashley actually seeks a lot of the same things as them, revoking the entire subpoena. She says that Lively is not a voice of women. She keeps talking for women and she keeps hurting women. So I think let me put it this way. I realize that people don't like Judge Lyman and they think that he's corrupt, and he has filed a lot of cases and rulings that are not in the favor of Wayfair. And from my experience, I've been part of numerous I've been a part of federal lawsuits, and I've also been part of state lawsuits. Judges always take the complaint as fact because it hasn't been proven yet. So they have to always consider, in light of the plaintiff, most favorable. Evidence is always most favorable to the plaintiff in all cases because she's the one that brought this to the court. The failure that often happens in these kinds of cases, though, is that the narcissist goes into court, overwhelms the court with the same story over and over and over again, paints that side as dangerous, thus making that side look suspicious. And rulings during discovery can appear to not be favorable, but some of these rulings, even though they don't go in the favor of Wayfair, in the grand scheme of this case, aren't that significant. Okay. And in other places where he's needed to be fair, he has been. Jed was dismissed. He told Lively that he didn't buy her smear campaign allegations under Jed, didn't believe there was a conspiracy. He basically discredited her entire theory in that case. And this judge has had other high-profile people in his court, including Andy Cohen of Bravo, and numerous lawsuits against him, where he's ruled in favor of Andy Cohen and thrown out the plaintiff's case. Because at the end of the day, it doesn't matter who Blake Lively is, and it doesn't matter who Ryan Reynolds is. If they're trying to take away the rights that are afforded to all of us under the law of freedom of speech and the First Amendment right, a judge cannot go against what the law says. And if they do, they can be appealed. And then if they are appealed and it's overturned, they get reprimanded from the appeals court. And it goes against them on their record. And the more times they get appealed and reprimanded, the less likely they're going to get these high profile cases. There's consequences to judges not following the law. And judges don't want to get scolded by their appeals court because the appeals court are above them. And it doesn't look good for a judge to blatantly disregard the law. And an error like that can get them in trouble. So Blake spent a lot of time telling everyone that we are dangerous, that Brian's dangerous, that Justin's dangerous. Well, now it's coming back to her. And she's going to start hearing over and over and over again from all these content creators that she gave an open window to the court. She literally subpoenaed all these different accounts, 7 on TikTok, 20 on X, and 16 on YouTube, for a total of 43. I don't know why people keep saying 38. Maybe there's some overlap between the two accounts. I don't know, but that makes 43 to me. And she's inviting them to file into the court and sharing their side of the story, allowing them to give a voice to the public organic backlash, something that Wayfair hasn't been able to do. They've been telling the judge over and over and over again that it is organic, but the judge hasn't heard from any of those people. And so now this is their opportunity and our opportunity to tell the judge this is organic and give insight into why it was organic and what she's doing. So she's really indirectly destroying her case this way, because the more the judge reads that she's the problem, that she's the one that's doing this, that these claims are baseless, the less likely he is to rule in her favor, because it's going to overwhelm the court. And he has to follow the law. He has to, or he can be appealed. I don't like him as much as most of you, but I've also gone through court cases where I have a judge right now that in my case against Robert Shin, or the case he filed against me, that hasn't ruled in my favor anything ever until last week. And it was the biggest one I needed. So just because they get wins along the way doesn't mean they win the case. It doesn't mean that she's in his bag. And in fact, the judge said to the court, I didn't even know who she was. I didn't even know who she was. So he's trying to distance himself from claims that he's being unfair. What really angers me, though, is that he's even entertaining her overbroad and abusive and invasive subpoena on Brian Friedman's law firm, which is a retaliatory one that she filed because of them telling the court about the Van Zandt's subpoena. She might get small wins along the way, but she's not going to win the case. And I have a sense that this subpoena is going to get tossed. Some of you have asked about when mine's going to be filed. My attorney is working with Shasti's attorney and Janessa, who has the astrology page, who people thought were AI. Janessa's a very real person. So her attorney, Shasti's attorney, and my attorney are all collaborating. And I think they're going to be filing a motion to quash jointly. I just don't know when they're filing it. So I'll keep you posted. And once it is up, I'll tell you about it. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.